This case management conference is in the matter of case number CFI 015-2019 before His Excellency Justice Nasser al-Nasser. The hearing is being held by way video conference in the DIFC courts in Dubai. The claimant is represented by Synergy Disputes and the lead counsel is Ms. Louise Wright. The defendants are represented by HFW and the lead counsel is Mr. Nicholas Berganza. Thank you.
Thank you. So the claimant may start.
If I could just start, Your Excellency, with a housekeeping issue. I noticed that we were introduced as the claimant being represented by Synergy Disputes. That's not the case. That's just an email domain that's being used. I'm here as Part 2 registered practitioner. The claimant is currently litigant in person, so just to confirm that point. That may change in the immediate future. And Part 1, the firm acting on the claimant's behalf is likely to be a little bit more clear.
Okay.
So, sir, moving on from that, it's quite clear to see that this case has had a catalogue of perhaps errors from the beginning. That I would like to clarify, and I'm sure it's known to the court, is no fault of either the counsel currently representing the claimant and counsel representing the defendant. Both counsel and firms were brought in at the 11th hour, so we're both quite new to this case. And it is a shame that we are where we're at, because despite all the pleadings that are clearly before the court and all the applications that have gone before the court, when we look to the actual core of this case, it is perhaps a little bit more straightforward than the pleadings would depict, which is why both my friend and I have been working together to try and ensure that this case will be ready for trial within the 6 months, and a date has been put forward around May, although of course we await the court's confirmation as to its availability on that point. There doesn't seem or appear to be anything controversial that's likely to happen in the course of the preparation for trial. And certainly I can say on behalf of the claimant that if there is anything, which I believe, having spoken to my friend, that there may be applications for request to produce, etc., or documents that would help the defendant in this case position itself, then we will be in a position and we will be cooperating to get all of those documents as soon as practicable. And if that's before any request to produce, then that will be done. So that's an assurance that we can give the court on behalf of the claimant. It may well be, Your Excellency, if I could put forward that it is quite clear the claimant, having been guided by those previously representing him, has put forward 5 particulars of claim that perhaps have been vague or incorrect in the law that it has relied upon to bring this claim. That is not helpful for anybody. It's not been done through any malice, and it's not been an intentional error on the part of this claimant. But that being said, of course, we are where we are, and it hasn't been helpful to these proceedings. Having spoken to my friend over a brief conversation on Wednesday, Your Honour, I think it was Monday, it may well be that we could submit something to the court, and I don't propose that's an amendment, further amendment to the particulars of claim, but it may well be with the court's guidance that we can certainly submit something in the form of a clarification to set out the claimant's stalls correctly. That is not to say there will be any new pleadings or new heads of claim, of course. It is merely to set out what it is, what the correct law is that the claimant is relying on, and perhaps give a little bit clearer calculations as to what the claim now is based on the correct law and on the pleadings that have already been put before this court with regards to the correct heads of claim. So I will leave that in your hands, and I will, of course, allow my friend to come back on that point if he's agreeing or if he's in agreement to anything being put forward in that regard. There is no application to be made today on behalf of the claimant, so I'm not applying. This isn't an application to amend the particulars, but I am in the hands of the court as to perhaps putting something forward that would help this court and help parties to try and speed this case along, because it's had unnecessary delays, perhaps out of the hands of the claimant and the defendant directly, and it may well be that they've acted on incorrect advice. So at this point, is there anything I can assist with as to where we're at currently?
Let me hear the defendant first, point of view, and then I'll come back to you. Yeah? Thank you.
Thank you.
Thank you, Your Excellency. I think that my friend makes some good points. I think that it should be highlighted that this claim was filed over 3 years ago. There have been 5 amendments to the particulars of claim. This is, you know, there's no malice perhaps, but there is certain almost, you know, negligence in the fact of the claimant trying to plead his case correctly. And I take the point from my learned friend that, you know, this isn't her doing, and it may have been his previous advisors, but the defendant has had to incur the costs, significant costs, over the course of a number of years, a number of hearings, applications to be heard by the court, and significant prejudice has been felt by the defendant in the claimant's actions and conduct during the course of this proceedings, which cannot be left, you know, to unaddressed. Can I say? I think that now my learned friend is suggesting a further amendment, and Your Excellency will have seen the pleadings and the almost confused nature of it. It's still unclear to me. As my learned friend mentioned, I'm also recently instructed on this case and taken over from Emirates Legal. But it's unclear what law the claimant is seeking to rely on. We had a case with respect to the original particulars that it was the 2005 law that was then changed to 2019 law. The Court of Appeal obviously has issued its decision and indicated that that was incorrect. So there have been a further amendments, but there's still a lack of clarity. There's still a lack of clarity on the quantum of the claim. We are unclear as to the sums that the claimant is seeking. But if it is the case that the claimant now wishes to amend yet again, you know, it needs to be done quickly. You know, we will, you know, we'll need to see what is proposed. The last amendment, which was made in April 2022, obviously made some amendments which were not permitted. Now that has just been let to slide, and you know, it may be the case that that they can plead that case in that way, but there have been amendments made which have not been permitted, and the claimant goes back again and again and again to the court for permission and is granted permission again and again. There is no sanction. There is no cost order that has been paid. There's one cost order which is outstanding with respect to the first, the second immediate judgment application. That's not been paid. So how long can this go on? And I think that if it is the case that there is a further amendment application made by the claimant, then the costs of that amendment will be paid, and they will be paid as soon as those costs are incurred, and we cannot wait for this to be postponed till the case is determined, costs in the case, etc. So in respect of the amendment, we're open to it. Let's see, if it is the case that they wish to amend a formal, they need to seek our approval. Of course, it's the courts, the case law indicates that amendments should be done with consent to the extent possible, and we will look at those amendments when they're made. But I cannot say now that any amendments which need to be made. I note that my learned friend talks about a note of clarification. I don't really understand whether that's possible or understand what that may be. I think that if she needs to amend, she needs to amend, and the correct process needs to be followed.
I agree.
Thank you, and I'm in agreement. I think what has been quite clear over the course of preparing for today's hearing is that my friend and I are quite keen to cooperate with one another to try and make more clarity as to where we're at. And I agree with my friend that, as I've already highlighted, that there has been 5 pleadings, particulars of claim, where it is still unclear exactly what the calculations are, what the quantum of the case is, and of course it needs to be highlighted under what law that is brought. I do wish to come back on one point that my friend has raised with regards to the latest particulars of claim, and I understand why my friend is submitting that. But with regards to the amendments that were made in the latest particulars of claim, we were quite restricted in what we could do, because what the claimant was not doing in the, let's call it the particulars of claim number 6, the latest, the claimant was not amending particulars of claim number 5. It was not amending particulars of claim number 1. Sorry, it was not amending particulars of claim number 1 because on the order, Your Excellency, your order of the 6th of April 2022, it was directed under no uncertain terms that actually it was particulars of claim February 2022 that was to be amended, and that is where what we were dealing with. So we couldn't go back to the original claim and make amendments. We were dealing with the February 2022 particulars, and we were therefore just making amendments to the law, and we couldn't go further than that. So I disagree with my friend slightly that we went out of scope of the direction. It was actually that we were having to deal with particulars claim number 5. That being said, we're still at the point, of course, where the case is unclear, and I agree with my friend on that point. Now, we don't wish to make an application to make further amendments to a particulars of claim formally. And the reason I say that is because the court is aware that it has powers in any event, and it has jurisdiction to amend any defects of the pleadings on its own initiative, and that's brought under the DIFC court law. The claimant could wait until its skeleton argument and put forward its arguments in that. What we're trying to do here is to say, we know that things are unclear and it needs addressing. I don't want to put my client in a position where it's going to cause the defendant to make an application for costs because we're making a further application to amend. What I'm trying to say to the court is we want to make things clear so that things can proceed far easily and far more clearly than they currently are. We could say, of course, well, let's leave it then. Let's leave it to the trial. Let's leave it to our skeleton argument. The court, as I've said, has jurisdiction under the court law to remedy any defects it sees. The case has been put. We stand by the claim that has gone to the court already, and that is that the claimant claims for outstanding employment dues. But as I said, sir, what I'm trying to do here is put forward an idea that we could perhaps do something that would assist the parties. Going back and amending particulars of claim in my submission, and respectfully, is going to cause just as much of a mess, because which particulars of claim do we amend? There hasn't been any thorough and clear particulars of claim that have gone before this court. And what would happen is there would be a 6 or 7 page red line document put before the parties where everything is amended. What I propose is that we set out succinctly bullet points, if the court would allow, exactly what law is being relied upon, but not deviating from the heads of claim that has already gone before this court, and perhaps having an element or a section for the correct quantum calculated properly under the 2005, the consolidated version law, which this case should have been properly brought. It's a difficult one. I've never been in this position before where I'm proposing such like, and I'm sure my friend hasn't either. Whether the court has or not, we can only be guided. But sir, that is our position. We're here to help, and we want to do whatever that may be.
It depends on the consent of the defendant, but I think there should be something clear before the court, yeah, going forward, rather than having lots of particulars with, rather than the particulars being confusing to the courts.
Absolutely. I agree with Your Excellency. I don't think things can just lay and you know, we can wait until skeleton arguments on the eve of the trial to deal with this. I think that we need to be clear now what is the case being made against our client, the defendant, and so it needs to be made now. You know, if it's the case that they start again, and the claimant files a new statement of a case, a new particulars of claim, so be it. But you know, the costs need to be dealt with. I don't think we can just indulge the claimant once again, and I would submit that the court should not indulge the claimant just to start again, just because it's had the misfortune of having lawyers who didn't do them well, you know. So I think that you know, if it's the case that needs to start again, then so be it. But you know, we should have our cost of any consequential amendments that need to be made.
This depends on the claimant. Anything the claimant wants on or how to proceed should be made by a consent of the defendant. If not, then by an application to the courts. Then the courts will decide whether in relation to costs and whether it grants this application or not, if there was no consent from the defendant. Yeah.
Absolutely, Your Excellency. Certainly don't want to start again, as it were, as my friend suggested. It's not a case of wanting to start again. It is just a clear. And in fact, when it comes to costs, what we're trying to do here is to try and reduce any costs for both parties. And if things can be dealt with sooner than what is about to be ordered within the case management order, then we will absolutely act on that. It is quite clear from the list of issues as to some of the questions that the defendant has, and the claimant would hope to alleviate those concerns through producing documents sooner than the court may direct. So when it comes to costs, we are certainly looking to keep those to a minimum for both parties.
Can I suggest then that my learned friend can, you know, is granted a period of time from now, is it, you know, a week, 2 weeks, to provide the claimant, sorry, the defendant, with its proposed revision, and you know, we can take a look at it and you know, maybe be granted a further week to review, consider, and give our consent or not consent, failing which the claimant can make the application to court, and that needs to be factored into the case management order.
Yeah, I'm fine with that if the claimant is also okay with that.
That seems a sensible approach, Your Excellency. I'm grateful.
So moving to the case management, I think there is an agreed list of issues, yeah, between the parties.
There has
Yes.
been, Your Excellency, yes.
And what about the draft case management order?
I think it's largely agreed. I think we may need to push the dates now if we're going to have a period to look at amendments. Obviously, if there is amendment to the particulars of claim, there will have to be amendments to the defence and reply as well. I'm not sure whether they can be dealt with before the 23rd of November, which is currently the next date set out in the case management draft case management order for production of documents. So I don't know whether we want to push that out by a few weeks, and then everything else moves as well.
That's certainly something that I think we can agree on. The other, I note from the defendant's case management information sheet that there perhaps was a difference of opinions as to the length of trial. The claimant proposed 1 day would be sufficient, but the defendant is under the impression that 2 days. We can see now from the form that the defendant is looking to call 2 witnesses. So therefore, with that in mind, we would agree that 2 days is more sensible.
Okay, the court is fine with these. What are the dates the parties are looking at? So you can then move all the way through that day.
The proposed date we're looking at is around May, Your Excellency, of next year, depending on court availability. What parties could do with Your Excellency's direction is perhaps give a revised case management order within 24 hours of today's hearing, including, of course, the submissions we've discussed.
Okay. Yeah. We're fine. Just Shahla, if there is an availability in May.
Yes, Your Excellency.
So May is fine. Which week is it?
What are we looking for? Which date?
Any week in May?
Yeah, probably the 2nd or 3rd week, I think, probably at this stage. Your Excellency, you'll be hearing the trial in...
No, not me.
From the registry side, May is looking pretty open.
Okay.
Yeah, so then you can work by the 2nd or 3rd week. Yeah.
Grateful, Your
So
Excellency.
within 24 hours, you'll send us the agreed draft case management order, yeah?
Yes, Your Excellency.
Sure.
Then, okay, anything else from the parties?
Nothing from the claimant, thank you.
Nothing from our side for the time being.
Thank you. We'll wait for the draft case management and then the courts will approve it, seal it, and send it back to the parties, yeah?
Grateful, thank you, Your Excellency, and thank you for the court's indulgence and patience throughout this case.
Thank you, both parties. Thank you.
Thank you.
Have a good day.
You too.
Bye.